sentence, Remy. So why that sentence had to say both things? It's just keep reading, and it says clearly in there, in violation of state law against blah, 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 blah. And like I said, this argument is not complex. You know it's in the papers all over the place. The word fair use is in the papers all over the place. The word malicious use is all over the place. Those are the key ingredients of this whole fucking case, okay? If you maliciously slander somebody in your distortion of their content, you are no longer fairly using the content. That is my claim. And I believe the case law supports that definition, that would not be fair use, because it would not be for educational purposes or entertainment purposes. It would be for deliberately malicious purposes of degrading somebody else's character and public perception. All right, and that would not fall under fair fucking use. It's a perfectly reasonable claim. It's in the fucking goddamn claim. It's right there, putting right in front of the goddamn court. Judges would wish to have claims this fucking clear. The law is stated right. We're pointing right to the dispute. That's what they want. They want to know what the dispute is, and we're pointing right the fuck to the dispute. And the dispute is, what is the definition of fair use, and what is the definition of slander and libel in the digital age? And I've made it goddamn clear. That's what this case is about.
It's perfectly correct when she says that you provide no factual support for any claims of libel. It's just...
She says no factual allegations. Remy, those are factual allegations. You want to play a game? Let's play your fucking game. All right? But your credibility is fucking zero. You're going to say those aren't factual allegations? Then you're a fucking asshole. You're an idiot. You're a moron. You're too stupid to communicate with.
You just don't. This statement may be said to support a claim of copyright infringement. But then the question is, does it lead to a possible or plausible conclusion that copyright violation has taken place? And clearly it's the latter, isn't it? It's more in the realm of problem.
Yeah, no, well, he's saying it's former.
So defendants have produced numerous videos.
There, you just said it. You just said probable. You just said it. You said the fucking word probable. And that's not the fucking issue, jackass.
But then the question is, does it lead to a possible or plausible conclusion that copyright violation has taken place? And clearly it's the latter, isn't it? It's more in the realm of possible than probable. So defendants have produced numerous...
Okay, you heard it, right? It's more in the realm of possible rather than probable. He said it, okay? Freudian slip, bingo, bango, bango, bingo, bungo, bingo. And I mean, not even slip, okay? It just reveals the fact that he has confused these words. And that's that simple. He's fucked these words. He doesn't know that probable does not mean plausible.
Used in various manifestations of video content produced by the plaintiff. That may mean that they have violated your copyrights, but it may not mean that you violated.
And that's why you have a trial and you prove your goddamn case. Or, if you're sure you're innocent, you file a summary judgment motion, you get one shot at it, you file your fucking motion, and you demonstrate why, well, look, I don't have a YouTube account. Or, I never made any videos using anybody else's content ever. Or, I never said anything about his personal character. I never made any accusations that somebody could think were derogatory. And you prove it. You show one of your videos. Jojo can't show one of his videos, and you goddamn know it. He can't defend himself against this accusation without bringing into court something as ugly as that fucking Hitler image, which I have now sent to the court. Okay, that's what he'd have to do. He'd have to show, look, this is what I did on YouTube. See how innocent I am? No, that isn't going to fucking work. That's going to be probable. It's going to be all over that fucking goddamn thing. So he's going to win a summary judgment motion if you do it fucking properly, the way the law demands. But we're not doing it that way for one fucking reason, Remy, because the judge is cheating me. She's cheating the system. She's cheating the fucking rules. And that's the only reason why you're able to make this little snarky, shitty fucking video. Is because this is complete bullshit. I can prove my goddamn case if I'm given a goddamn chance to do it. The case law's on my fucking goddamn side, in that it doesn't fucking exist.
You yourself appropriate the video content of other people when you make your call and response video.
Right, and you don't see any difference in that. So when I play your video, and I'm doing commentary, and I'm not distorting you or perverting you in any way, I haven't maliciously manipulated this scenario in one fucking way, all right? Any kind, there's no maliciousness written on this whatsoever. Not one fucking piece of evidence of any maliciousness. So yeah, that's fair use. Fairness is when you're not malicious and you don't distort to your advantage. When you distort to your advantage, that's the opposite of fair. You really got to know the difference, right? You know what the word fair means, don't you? And it's fair in every meaning of that sense. It's very appropriately called fair use. Because it's not only about you fairly having an opportunity to use somebody's content to do what you need to do, okay? It's about need, but it's about being fair. I mean, both definitions are appropriate to that fucking clause in the fucking law. You don't have an exemption to somebody's copyright if your intent is malicious.
You play back somebody's video and then you interpose your commentary, and it's perfectly legitimate. That's fair use. So in order to make a plausible case that your copyright has been violated, I think you need to supply additional facts. You need to...
Bullshit. Again, bullshit, bullshit, bullshit. Okay? Without arguing case law, there's no way you can go from a complaint to this standard you're establishing. It's just nonsense. You'd have to start arguing case law in the complaint, and that would be fucking ludicrous. All we need for plausibility to exist is the idea that this guy had an account, I had an account, he used my content. Okay, that's a fact the judge has to accept as true. All right, my allegations have to be accepted as true, and then she has to say it's implausible after she's accepted them as true. So I've stated that we have accounts, that they stole my content. That's my content, they stole it, they used it inappropriately, they violated a state law against slander in doing so, and that fucking violates the fucking copyright law. Now, how can you make that into something implausible? If you have to accept those stated facts, how can it possibly be implausible that he's guilty without arguing case law, Remy? It's fucking impossible.
Beef up the factual portion of this complaint. Yeah, so that is exactly what Judge Harmon found. She said that this.
No, she found a loophole, okay, and the loophole that isn't going to fucking work anyway, because in 3 places in my subsequent documents I say I'll give you whatever the fuck you want. You want more? I'll give you fucking more. I'd love for me to be able now to force the judge to watch hours of video. And maybe I'll give her the weakest evidence first, just so I can force her to watch hours and hours and hours of videos, of my videos. I'll force her to watch, I won't index them. I won't tell which videos are which. I'll give her fucking 500 fucking videos and say, yeah, well, these prove that I'm a philosopher, and some prove this, and some prove that, and some prove this. Yeah, okay, let's go there. I'm all for that.
It doesn't meet the standards of the 2 cases that she cites, and therefore it must be dismissed. And I don't agree. I find it hard to argue with that. I think just about any objective person looking at the standards that are laid out.
Your perversion of the standards. Again, you used the word. You said it. Okay, probable. You didn't say plausible. You said probable. All right, and we know that your definition of plausible is insane. Plausible does not mean it looks more like this truth is true. That's not plausible, Remy.
Those cases, and then looking at this complaint, we find that the complaint is defective.
You know, people use the term more plausible all the time. What do you think they're really saying? They're saying more possible, aren't they? Aren't they, Remy? Aren't the words basically interchangeable, except one just sounds a little bit narrower, doesn't it? Plausible does sound a little narrower than possible. You're such a fucking cunt. And, you know, whatever.
Even arguable that it does what a complaint is supposed to do. Now, anyway, that's what I wanted to tell you. I have a lot of questions about this case. You're going to allege that the judge reached this ruling for malicious purposes, and I don't know.
Yeah, that just sounds a little silly because, it's not like she dismissed the case already. Well, I guess she sort of did when she said you have to go to Texas, and it's an established fact that you're not going to Texas. So I guess she already did dismiss the case, but we'll ignore that truth, and we'll ignore that she pulled a motion that was 17 months old out of her ass that Hittner had read, and that the appeals court had read my complaint, and they obviously didn't say, oh my God, this complaint is a piece of shit. No, that didn't happen, which it usually does. Appeals courts will look for any kind of excuse to say, okay, well, the judge was wrong, but the decision was still okay, and we're going to keep that decision. So if the appeals court thought the complaint was obviously vacant and incomprehensible, they would have just said, you know what Hittner did is wrong, but your complaint is shit. There's no cause of action here, so, dismissed. That's what they would have fucking goddamn done, Remy. You dumb fucker.
That may even be true. I have no idea.
Yeah.
I'm sure she was somewhat miffed by your behavior. It just isn't very smart to go.
It's not about her being miffed. What it's about is the fact that she's a weasel on the court, and she will manipulate the law and the court rules to get to do the justice she thinks is justice. She won't obey the law. She won't obey the Constitution. She won't obey the principles that have been built into that structure. She will instead manipulate and distort the truth to perfect her evil doing, and that's what she did here. Okay, she. All right, like I said, her own statements have in them gross inaccuracies. That's not acceptable. She stated that I said I didn't serve the other defendants, where I clearly explained that I did serve them with appropriate waivers, and that I now need to get court orders to have them served by a fucking marshal at their fucking expense, because that's the fucking law. And if I do it at my own expense first, then I'm going to be fucked.
Disrespecting the sitting judges in an active case. And who knows, maybe she would have looked more charitably on your case if you behaved.
Yeah, well, that's not what you go to a court for. You don't go to court for no goddamn charity. You don't bake no fucking cookies. You don't do any of that goddamn shit. They're supposed to be goddamn honest umpires. That's all they're supposed to be, is mediate to mediate a dispute between 2 people. That's their fucking job, is to basically umpire the dispute and say, this is what the law says. Okay, and I will apply the law to your circumstance. She would not allow me to have my dispute. She would not mediate the dispute. She ignored the fucking dispute. This dispute put right in front of her goddamn face, argued by me and both Joneser. Joneser was arguing fair use law in his goddamn papers. You gonna deny that, you dumb fuck? He obviously knew what the claims were, and he was arguing them. And as soon as he started doing that, there was a goddamn cause of action.
Anyway, that's the way it goes. But a question I had was, first of all, why did she not allow you to amend your complaint? And the second question,
well, because it's better to destroy it. She didn't want to amend it. She wants to destroy it. And she had the motion that Joneser filed. He didn't properly name it. It was just a letter he sent, okay? But it was clearly a motion for more information. It was clearly a Rule 15, is it? Yeah, well, I think it's Rule 15. It's 15 or 16. No, it's back to Rule 12. Yeah, it's Rule 12. Rule 12E. Rule 12E. You go read that, and it says right there, that's the motion basically that he filed. I want more information. I can't really understand the claim against me, the pleading against me. So without the pleading and a complaint, it's just, interchangeable words. So he didn't understand the pleading. It's not enough information. I want more information. And all the judge had to do was approve that motion. That's all she had to do, and then I would have to sit there and give Jones or whatever the court said I had to. But that's the qualifier here. The court did not want to have to try to explain what was deficient, because there is no fucking deficiency.
That would be why did she dismiss with prejudice as opposed to without prejudice? And,
yeah, well, she can't do it with prejudice. The appeals court's going to laugh at that part, but that's just a fucking joke. She made no fucking... She's established no fact. She'd established that she can't establish the fact that he didn't violate copyright law. It's fucking impossible. It's impossible for her to establish it as a fact that he did not commit slander and libel. So it's just impossible for her to make a with prejudice ruling with any fucking credibility, because she has not demonstrated those two claims to be implausible. She's demonstrated nothing. She's argued nothing. She's just basically said no. No. That's not